Somebody got it. Internet.
We have 4 of us.
Mm-hmm.
Need one more.
Thank you for starting the recording.
Well, I figured I got to be able to do something.
There's Knight.
Hello, good morning.
All right, good morning.
Good morning. Just
Good morning. We will now call to order the May 5th meeting of the Ohio Elections Commission. Roll call, please, Mr. Executive Director.
gladly. Mr. Kreitz,
Here.
Ms. Hagan,
Present.
Mr. Knight,
Here.
Mr. Lyle,
Present.
Ms. Kaufman,
Here.
Mr. Beatty, or Chair Beatty,
Here.
excuse me. Ms. Tavares. Sorry, Ms. Tavares is not online yet, Mr. Chair.
Since we have a appropriate quorum, it's my recommendation that we
She
proceed.
just texted, she said she's trying to connect.
She's in.
She's in.
Is she in? Ms. Kaufman, we already did Ms. Kaufman. Ms. Tavares?
I was having problems joining from my Teams program, but I'm here.
Okay,
Thank
great.
you.
Thank
All right.
you. Yeah, we have those little problems
All
every
right.
now and there. Then, okay.
Okay, the first order of business will be the approval of several sets of minutes. First is the approval of the probable cause panel meeting minutes of April 21st, 2022.
And I'll quickly add before we go any further, Mr. Chair, since we haven't done probable cause panel minutes in a long time, only the members of the panel should move, second, and or vote on those minutes.
I'll move, Mr. Chairman.
I'll second, Mr. Chair.
Okay,
All in favor, then signify by saying aye, raising your hand.
Aye.
Thank you.
motion passes. Next will be the approval of the regular meeting minutes of April 21st, 2022. Do we have any questions?
So moved.
Okay, is there a second?
Second.
All in favor, please indicate by raising your hand and saying aye.
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 Seeing no opposition, the motion passes. The third set involves the approval of the regular meeting minutes of May 2nd, 2022.
Mr. Chair, I move approval of the regular meeting minutes of May 2nd, 2022.
I'll second.
Is there a second?
Second, Charlita.
Okay. All in favor, please indicate by saying aye or raising your hand.
Aye.
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 Any opposition? Seeing none, the motion passes.
Thank you. Thank you, Mr. Chair, members. Thanks for your patience on me getting those May 2nd meeting minutes done at the last minute and sent out to you yesterday evening. So thank you very much for your quick approval of those.
Next on the docket, we will proceed with preliminary reviews. For the sake of expediency, we will change the order up a little bit. And the first case that we're going to call would be the case number 2022 G008, Gebhardt versus Antonins.
Yeah.
Okay.
No, yeah, go to members. Mr. Gebhardt, the complainant, is here in person. He's going to be on Chris's computer. And we also have counsel for the respective respondents. Mr. Brown is on behalf of Mr. Antonetz, and who is also present remotely. And then Peggy Guzzo is present on behalf of the respondent Dynalab. I have circulated the complaint and all materials that have been submitted to the commission for this matter. We could hear further from Mr. Gebhardt and respective counsel if the commission wishes to do so. You can see my recommendation is to find no violation against the candidate and committee, and to find a violation and impose a $50 fine against the corporate respondent. So you have my recommendation, you have the materials. Mr. Chair, if you wish to hear from Mr. Gebhardt further, we could have him sworn and he can make an additional statement.
I assume you've shown up, so you would like to be heard.
Yes, sir.
All right. Let's swear the witness, please.
Would you raise your right hand? Do you swear or affirm that what you are about to tell the commission is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Please proceed.
Thank you, Mr. Chairman and members of the commission. I am Carl Gebhardt, and former township trustee in Genoa Township for 12 years, and currently still a resident of Genoa Township. Mr. Antonetz served as treasurer for Antonetz and Genoa, for Antonetz for Genoa, his campaign committee. Training had been provided by the Delaware Board of Elections for new candidates, and I assume that campaign finances were a major topic during this training. I do not know if Mr. Antonetz attended or not, but the training was provided. The only other in-kind contribution received and reported on the post-general finance report was from the Genoa Township Residents for Responsible Development for $800. So the Dynalab contribution did not get lost in the number of contributions. There were only basically two, which brings up an interesting issue regarding the other contribution and Ms. Guzzo's representation in this project, since she was also lead counsel on a federal lawsuit brought forth by Genoa Township Residents for Responsible Development, of which endorsed Mr. Antonetz in the campaign. Mr. Chairman and members of the commission, I did not receive the motion to dismiss from Mr. Antonetz's counsel. It appears that it was sent May 2nd. I have not received it, so I had a chance to look at it with 10 minutes to respond. I'm not looking for a pound of flesh here, but I think what we have here is maybe similar to a scenario where, let's say, a bank robber goes in, robs the bank, got caught, and says, hey, I returned the money, so we're good. Granted, this doesn't rise to a level of bank robbery, but I think the concept is the same. The in-kind contribution was made October 27th, and it was filed as Dynalab Incorporated. Mr. Antonetz, as treasurer, should have recognized this as a corporation, done some investigation at that time, and made it whatever changes were necessary. Mr. Antonetz apparently did not question the contribution, even though, as treasurer, he should have. The contribution was spent, the election was held, Mr. Antonetz won. And until I filed the complaint 6 months later, based on my investigations and actions into it, people did not get concerned. And again, 6 months after the election. It's good that Mr. Antonetz and Mr. James are taking the necessary steps to finally rectify the situation. But it appears only because I filed a complaint. Sure, the money was returned, but the bank was still robbed. I'd like to quote from Mr. James. And again, I put the burden of responsibility on Mr. Antonetts. He was the candidate. He should have had the training, should have had the knowledge. Mr. James appears to have been wanting to make a contribution. Somehow, as a result of his accounting, things got messed up. And it was basically not corrected as a personal contribution the way he alleges to have intended it. But Mr. James made an interesting comment in an article in Smart Business, July 2022. He says he specifically slams the laws of repress small business. And, quote, politicians who argue don't hold themselves to the same standards of ethics and the same policies they set for their constituents, end quote. I agree with that. I think regardless of whether you're a township trustee or whether you're governor, you have a certain responsibility. If you are taking on the responsibility of also being treasurer for campaign, that adds another layer of responsibility. Again, I'm glad the situation is being rectified, but the genie was out of the bottle. And it's hard to put the genie back inside. So I'm asking that at a minimum, the commission find Mr. Antonetts did in fact violate 3599.05. I thank you for your attention.
Okay, thank you. Next, let's hear from Mr. Brown, representing Antoinette.
Thank you, Mr. Chairman. So Mr. Gephardt used an analogy. The analogy was that a bank robber steals money from a bank and then gives it back to the bank. And that's not a good analogy, because this is more like a bank robber steals money from a bank and then goes and buys a car with it. And then you're going to charge the car dealer with the crime. And obviously that's not what we do. So the what happened was Mr. Antonetts ordered some marketing materials, and Dynalab paid for them and let Mr. Antonetts know that Dynalab had paid for them. And so Mr. Antonetts reported it as such, which is his only duty to do. And Mr. Gephardt has asked you to charge him with wrongdoing under 3599.03A1. I'm going to read that statute to you in part. No corporation, directly or indirectly, shall pay or use or offer advised consent, agree to pay to use the corporation's money or property for or in the aid of a candidate for election for nomination for public office or for any partisan political purpose, shall violate the law requiring the filing of an affidavit or statement respecting such use of those funds. It's clear from the language that this law only applies to the corporation. And so by law, the commission does not have authority to issue a violation against the candidate or the campaign under the plain language of the statute, as it refers to no corporation, and that's all it refers to. And again, Mr. Antonetts was not even involved in the actual transaction itself. He merely reported it, which we have explained in the past that the treasurer's only duty is to report the information that's given to the treasurer. So again, the commission doesn't have authority to hold Mr. Antonetts accountable or liable for this. It appears Mr. Richter agrees with me, and so I'm glad that we're in agreement today. So thank you very much.
Okay, and I believe we have counsel for Dynalab here. Is that correct? We're going to identify that person.
That's correct. Ms. Guzzo is here on behalf of Dynalab.
Yes. Can you hear me okay?
Yes, we can.
All right, thank you. May it please the commission, Attorney Peggy Guzzo, our number 00892217 on behalf of Dynalab Inc. And we did submit a response to the commission. Basically, it was a situation where Mr. James, who is someone that often gives to many organizations and charities, and in this case, Mr. Antonetts, Mr. James is not a resident of Genoa Township, but knows Mr. Antonette's from a professional engineering services that Mr. Antonette's provides. He learned that he was running for an office. He liked Mr. Antonette's and offered to pay for his printing expense. Mr. Antonette's indicated he needed some assistance with that. So as normal business for Mr. James, he has, his mail sent to his office. It was sent to his office. At the time that the payment was made, it was inadvertently processed and paid as a vendor to Minute Maid Press. And then upon receiving the letter from the Election Commission, they looked into it and realized of the error. So they immediately took corrections and corrected it. And so just a couple things I just wanted to just respond to Mr. Gephardt, which we do appreciate Mr. Gephardt bringing it to Dynalab's attention, as well as the commission. And I'm not really sure what Mr. Gephardt's reason for bringing up my prior representation of Genoa Township Citizens for Responsible Development. Mr. Artonette's was never a client of mine, wasn't a member of that organization, at least not to brought to my knowledge, and I did not represent him. So Dynalab is a client of mine, and I had them prior to representing Genoa Township residents. So there's no relationship there. The second thing is to counsel for Mr. Artonette's. He had indicated that he reported what Dynalab had indicated to them as far as making the payment. That's not the case. It was Mr. James who had said send it to his office, and he did pay for it. Unfortunately, inadvertently, it was Dynalab, but once they realized it, that's when they sent a letter to them. I believe it was March 22nd, after the commission had informed them. We don't believe the intent was there, but we certainly understand the situation, and we just ask that the commission take that in consideration, that it wasn't a situation where Dynalab made it, the contribution, and didn't realize it was wrong. This is a situation where they made the payment, but they didn't intend to make the payment. It was processed as a vendor payment, not as a contribution to Mr. Artonette's. They never intended to make a contribution to him. Thank you.
Okay. We've had the opportunity to hear from all three involved priorities. Mr. Executive Director, do you have any comments at this time regarding your recommendation?
I'll be glad to answer.
And then I will turn to the commissioners as to if they have any questions.
I'll be glad to answer the questions the commission members may have, but I've made my recommendation primarily as it relates to Mr. Antonette's. If you read the submission by his counsel, 359903A only applies to the corporation or that aspect of things. 359903B, and that's what was cited in the complaint. 359903A broadens the responsibility for corporate activities, and that wasn't invoked in this particular circumstance. So that's the basis for my recommendation. Certainly, I believe, Mr. Antonette should have known better and should have reflected something. Should have made sure that wasn't proper or wasn't reflected that way in his campaign finance report. But the section of law that comes into play there isn't before us in today's proceedings.
Do the commissioners have any questions for any of the litigants? Seeing none, is there a motion?
Mr. Chairman, I would make a motion that we follow the recommendation of the executive director and specifically find no violation against the candidate or the committee, but to find a violation and to impose a fine of $50 against the corporate respondent, Dynalab.
Second.
We have a motion that's been made and duly seconded. Is there any further discussion or questions on the stated motion? Seeing none, all in favor signify by saying aye.
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 All opposed, the same sign. Motion carries by a vote of 7-0. Mr. Executive Director, closing out, any comments?
That's all I have,
Mr.
Mr.
Litigant.
Chair. Thank you. Sorry.
No, that's okay.
Thank you, members. Have a great day.
So what you're saying is basically it was the wrong section of the law that was cited.
If B had been included in there, then yes, there would have been responsibility, but the way A reads, it only places the responsibility on the corporate entity and others related to the corporate entity, not anybody, not a broader swath. So,
So it
yeah.
can be refiled.
I'm not going to comment on that, but if you want to do so, we'll deal with it at a time.
Thank you very much for your
All
process.
right.
Attorney
Thank you,
Guzzo,
members.
you
Have a
understand
good afternoon.
the decision?
Was that a question for me?
I think you're muted, Ms. Guzzo. At least we can't hear you.
You cannot hear me?
There you go. Now we can.
Okay, I'm sorry, did you have a question for me?
Yes, in relation to your client, you understand the decision?
We do, we do,
Okay.
Commissioner, and we thank you for your consideration.
All right, thank you very much.
All right. Good
All
afternoon,
right, the
everybody.
next case that we'll call on the docket is Daly versus the Law Office of Blake Maslin LLC et al. Case number 2022 G009. And I believe we have counsel here for both parties.
All right, I got Hartman.
Okay.
That sounds. Okay, there we go. Sorry, didn't mean to make it sound bad when I said I got Hartman, but I had spotlighted Mr. Hartman.
Mr. Executive Director, would you like to introduce the case?
Yes, Mr. Chair. This is a complaint that alleges that the respondent failed to file certain campaign finance reports and should have been either a PAC or a PCE based on the allegations. We received a response from the respondent that essentially opposed that finding. Mr. Hartman is here on behalf of the complainant. Mr. McTighe represents the respondents. And so if the commission would like to hear further from respective counsel, you can do so.
Mr. Hartman?
Thank you, Mr. Chairman. Yeah, I would like to be heard on it. I would note for the record the response that the respondents provided. I only received yesterday afternoon from Mr. Richter, was not sent to me at the email address indicated on the certificate of service thereon. So I've only had about a cursory opportunity to review it. But that being said, we are prepared to go forward. I think it's important at the outset that the commission appreciate procedurally where we are today. This is not a full merits hearing. This is simply a preliminary review under Administrative Code 3517-1-11. And pursuant to that provision, this panel or the commission is at this stage to determine jurisdiction, sufficiency of the complaint, and whether probable cause exists. And again, it is not for a determination on the merits, excuse me. And thus, hang on. I want to call up and I've submitted I'll just make reference to, I've submitted a memorandum addressing what probable cause is and what probable cause is not. And as indicated by courts here in Ohio, it's a flexible common sense standard dealing with probabilities, not certainties. It's not a determination on the merits. It's circumstances that warrant suspicion. And therefore, it doesn't require a prima facie showing of wrongdoing, only that a probability of wrongdoing existing. And that's where we are today. And I think if we look at the complaint, and looking at the response, the opportunity I've had, I think the respondents kind of misunderstand the issue. They like to focus predominantly, almost exclusively upon a federal registered PAC called Change the Judges, Change the System. That is not the issue here today, per se. The respondents in paragraph 12 of their response indicate that inaccurately that we make the allegation that the respondent law firm, that is the law firm of Blake Maslin, is actually a political action committee under Ohio law and failed to file the required reports. But then they proceed and mistakenly declare that these allegations are somehow stem from the erroneous assertion that changed the judges, changed the system, failed to file any reports or receipts from the law firm. That is not the issue. The issue is whether the Blake Maslin law firm, by their conduct in or about October of 2020, falls within the statutory definition of a political action committee. And I want to call up the definition of political action committee. This, there we go. You look, and this is really the application that this commission or this preliminary hearing panel is reviewing. Under the statute, political action committee means a combination of two or more persons, the primary or major purpose of which is to support or oppose any candidate, political party, or issue, or to influence the results of any election through express advocacy. And that is not a political party campaign committee, a PCE, or a legislative campaign fund. So that's the definition. The question is not what changed the judges, changed the system was, but whether through its conduct in and about October of 2020, Blake Maslin law firm satisfied that statutory definition. Clearly established that it is a combination of two or more people. The law firm has at least 9 to 10 attorneys. Even Mr. Maslin acknowledges that with one of his colleagues that they were undertaking the effort to influence the November 2020 election. But I want to go a little bit further in this statutory definition for the commission, because that definition continues and excludes a certain item from within the ambit of being a political action committee, which I think is very important for the commission to consider. It declares that a political action committee does not include one of the two following, and the first one is the applicable one. It does not include a continuing association that makes disbursements for the direct cost of producing or airing electioneering communications, and that does not engage in express advocacy. I think there is no dispute that the law firm of Blake Maslin is a continuing association. It is, generally speaking, a personal injury law firm. But it did not make direct costs for producing or airing electioneering communications, and it did, in fact, engage in express advocacy by its purchase of the advertisement in the American Israelite. There's no dispute that Blake Maslin's law firm made the expenditures for numerous matters, radio ads, the advertisement American Israelite, and other things that are not quite clear what all they spent, as reported to the Ohio Secretary of State, of over $324,000 in expenditures made by Blake Maslin law firm in a 15-day period. $324,000 in a 15-day period. I would submit to the commission that that at least raises probable cause, a suspicion that what the primary or major purpose at that time frame of Blake Maslin law firm was to influence the results of an election and to support judicial candidates, as they acknowledged they were doing in Hamilton County. That's the issue. It does not fall within that exception, and therefore, as a continuing association, it can and does fall within that statutory definition. And again, we're looking at probable cause today. We don't have a full evidentiary record here ready for the commission. I think one of the pieces of evidence that we have before the commission is very telling in terms of the activities of the Maslin law firm. This is Exhibit H to the complaint. It is the agreement by which Blake Maslin law firm purchased radio time. You see, it's saying this, the time was requested by the law offices of Blake Maitland. And interestingly, and it's, the gamesmanship that we're engaging in, that the Maitland law firm was engaging in, it says, Blake Maitland law firm's asking for it. It gives an address of Francis Lane in Cincinnati. And says it's doing it for Change the Judges, Change the System, who has a different address over in Moraine, Ohio. But as we established in the complaint, those two addresses are the addresses both for the Blake Maitland law firm. You look at the telephone numbers, it's the same. You look at the email addresses, it's the same. It was Blake Maitland law firm that was engaging in the expenditure of funds as a combination of two or more people for the major purpose during this time frame of supporting candidates or influencing the election. If you go down to the second page of this agreement, they're doing, say, their start run times here towards the bottom right. It was going to run from September 29th to November 1st of 2020. That was the focus of Blake Maitland law firm during this time period. When you look at the magnitude of the monies they spent, and even if it wasn't that high, even if it was in the hundreds of thousands for a judicial race in Hamilton County, that is still a lot of money. I can say that both objectively and subjectively from personal experience. So the issue goes back to this definition. And is there probable cause that needs further exploration, further development of an evidentiary record in order to determine the scope and the principal purpose or the major purpose of the Blake Maitland law firm? They were the ones that made the expenditures. Because what you have, and the way these things are now reported, is basically you can have an LLC who does all the buying of everything for a political action committee, hiding the source, any source of funding to that LLC, and all it says is, it's an in-kind contribution from that LLC. We don't even know how the money, where all the money came from. There's no indication of where the money was actually spent, because all it's reported is as an in-kind contribution, both contribution and expenditure. That undermines campaign finance laws. That is not consistent with the purposes of full and complete disclosure to the general public of monies in campaign finances. This commission finds there is no issue here, that what was done was perfectly legitimate here at the preliminary hearing stage. It will have set a dangerous precedent as to literally shenanigans that can be engaged in to avoid the campaign finance laws. That's why this thing was brought. The Maitland law firm clearly falls within the statutory definition of a political action committee, and as such, as a political action committee, it wasn't obligated itself, not through some surrogate, not through some other organization, but as an entity in and of itself, to file a designation of treasurer and to file campaign finance reports reporting its contributions and its expenditures. While it may be a continuing association or a continuing entity, it does not fall within that statutory exception by which the definition of political action committee does not apply. Therefore, we would ask that the commission find there is probable cause, set the matter for full hearing after further discovery. Thank you.
Am I being called? I'm not hearing anybody.
Mr. Beatty, you're muted.
That's right. Sorry.
All right.
There you go.
Are you ready to proceed?
Okay, thank you, Mr. Chairman. On behalf of respondent, So Mr. Hardman is correct when it was whether the law firm is a PAC. That's the allegation. We have to look at what the facts are that are presented in the complaint and complete.
Mr. Chairman, I'm having trouble hearing him. I'm hearing some interference plus.
I'm sorry, I was hearing some feedback. Okay, can you hear me? Okay. So what we have here is an allegation that made in-kind contributions to a PAC is itself a PAC. Complaint.
Mr. Chairman, I'm sorry to interrupt.
Mr.
Chairman, Mr. McTighe is breaking up for me. I'm not picking up everything he is saying. I don't know if that's happening to other people or not.
You're not the only one. It appears to be happening at least on what we're hearing as well. I can't speak for the other commission members. I have to ask you to be a little, I don't know, diligent, disciplined, Mr. McTighe, and not speak too quickly.
Sir, the only allegation here is that the complaint that in-kind contributions to a PAC. Okay, the PAC reported those. Report them both as being received from the law firm and by federal law reported them on the expenditure side. Unfortunately, the complainant solely upon information on the Secretary of State's website. But as we demonstrated through an email that we attached to our response, the Secretary of State's website does not record contributions received by a federal PAC, only records the expenditures. The complainant could have obtained copies of the reports on the FEC website, reports, which would have shown that for
I'm going to interject. Sorry, Mr. McTighe, hold on there. Ms. Tavares has been experiencing a problem as well, and she has signed out right at the moment and is in the process of trying to sign back in. So if you would hold on and give her an opportunity to log in again. She appears to be having a similar problem to what Mr. McTighe is having in terms of breaking up. She's on the listening end though, not the talking end.
And Phil, I am still.
So just hold on a second.
And Phil, just so I am still getting Mr. McTighe breaking up. I mean, I can kind of pick up the gist of everything, but I'm not getting full statements from him for some reason.
Yeah, Mr. Chair, this is Commissioner Knight. I am unable to follow Mr. McTighe due to breaking up as well. I would suggest that Mr. McTighe log off and log back on, because my sense is the issue's on his end, not ours.
More than likely, that's the case.
Okay, I will. So logging off. Okay, back on. Is that better?
So far, yes. I'm not sure I see Ms. Tavares yet. And so I'd ask you to hold on.
Okay, he's back. I mean,
Charlita's not here though. At least that's that I can see.
Well, Phil, are you able to hear me now without breaking up?
So far, it appears to be the case, yes. All right, Charlita.
Mr. Hartman, can you hear Mr. McTeague?
I
You're
have,
muted.
since he
Okay.
signed back in thus
All
far,
right.
it's good.
It appears that Ms. Tavares may not be able to participate, so we'll have six. We still have 6 members though. So go ahead, Mr. McTighe. Make your comments.
Yes, as I was saying, the years at the Political Action Committee, that is, however, correct and disputed by the evidence that we submitted.
It is starting to
The
break back
complaint-
up again. I'm sorry, Don. It's starting to break up again on my end.
Okay, let me back, maybe I'm too close to the microphone. Okay. The complaint is the complainant's review of limited information on the Secretary of State's website. In fact, what happened here, as demonstrated by the full FEC reports that we response, is that the PAC reported receiving in-kind contributions for every single in-kind contribution and report
Mr. Chairman, it is still
expenditures of the
breaking up
PAC
on me.
then made.
I don't know if anybody else is experiencing that as well.
Did you disable the chat?
Yes, I'm having something of an issue on my end as the court reporter here.
And we are too.
Well, maybe we're all having problems because that's why I had to click off and click back in. I thought it was just me.
Well, it's kind of random because we didn't have a problem with Mr. Hartman. We don't appear to have a problem on this end here, but other people appear to be having issues for whatever reason. And generally, I think it is internet connection related. Go ahead and try again, Mr. McTighe.
The basic facts here are that it made in-kind contributions to a political action committee. The political action committee reported those. This is no different than any other business that makes an in-kind contribution, candidate for that matter. It's important to understand what it says about contributions. There's 2 ways to make an in-kind contribution. You can allow someone to use your office space. That's an in-kind contribution. Somebody for that office space, and then you allow a political committee to use. Another way is you can pay essentially a bill that a political action committee might have. That becomes an in-kind contribution. That is all that happened here. This in-kind contributions, just like any other business can. The complaint of the complaint is based on total speculation received from some other persons other than coming from the profits of the law firm. That repeatedly stated in the complaint. So a situation like any other business making an in-kind contribution. There is no evidence complainant to establish that any funds other than revenue and profits of the firm were used in this connection. Not one piece of evidence. This is how in-kind contributions happen. And this law firm makes some significant in-kind contributions to a political action committee, and it reported everything and did everything by the book of how businesses make in-kind political committees. The complaint says that disclosure is the heart of campaign finance. That is true. Everything was disclosed here. The sources of the contributions, which is the law firm, and the expenditures as independent expenditures. So it's all fully reported. I think that the complainant misunderstood in relying upon when they relied upon the Secretary of State's website. We've shown that that's not, and we have provided the full record. As an aside, just although it's some, Mr. Hardman talks about the law firms making in-kind $324,000. Actually, that's not a correct computation. If you go to the actual and due to nuances on how things get reported on federal reports, the actual amount is $185,000. It's not really a relevant factor here, but it just shows that you have to actually dig in. These are reported. The law firm was required to, the PAC was required to report receiving the, it did. Mr. Hartman's complaint or Ms. Daly's complaint, Political Action Committee, rests solely upon speculation in the complaint that someone else chipped in money, that candidates chipped in money, or that other lawyers chipped in money, or other law committees chipped in money. There's not one bit of evidence submitted. The full record before that these were in-kind contributions by the law firm from the law firm's rep, and that everything was reported. Thank you.
Mr. Chairman, in rebuttal.
Did you say that you were completed? Thank you. Okay, rebuttal from Mr. Hartman.
Thank you, Mr. Chairman. Got to, address just a few of the points that Ms. McTighe addresses that we could have gotten the reports elsewhere. Well, what good are the Secretary of State's websites for campaign finance reports if you cannot rely upon them? Maybe that's an issue with the Secretary of State, but any citizen in the state should be able to go to the Secretary's website and get pertinent information in terms of campaign finance. That's why it's there. Ms. McTighe argues that what the Maisland law firm did was no different than any other business that makes in-kind contributions. I would submit to you that no other business makes in-kind contributions that constitute the entirety of the expenditures of a political action committee, also controlled by the same person. That is unheard of. Mr. McTighe, this is a political action committee. The political action committee, i.e. judges changed the system, and the law firm had the same address, same emails, same phone numbers, same person controlling. This is no different than any other business that makes an in-kind contribution, which makes all of the expenditures for the registered political action committee. Mr. McTighe says, oh, that he bemoans that we reference the source of the funding, that it's speculation, etc. Well, first and foremost, the commission again has to revert back to the statutory definition of a political action committee. And the source of the funding is irrelevant in that determination. This case is about whether Blake Mason Law Firm satisfies the definition of a political action committee such that it then in turn had to register and report. The issue in terms of the source of the funding, I think as important for the commission to appreciate is the precedent you're going to set. Because you allow a scheme, a system, whatever to be set up like this, you're opening the door for the funneling of outside of money into a campaign through some LLC who in turn then only does the in-kind contributions and does not make the actual contributions to the political action committee. It will be a dangerous precedent whereby in this situation, a law firm, other entities could very seriously and very easily then funnel money into a campaign that becomes unreported, unaccounted. That's why we brought this issue, because it is dumbfounding in a certain sense why the Mason Law Firm wants to set up a political action committee, does not make any contributions to it, but in terms of direct contributions, but only makes these in-kind contributions. But at the end of the day, the issue becomes whether Blake Mason Law Firm, for the 15 days, in that 15-day period in October of 2020, when, according to the evidence from the Secretary of State's website, it's over $324,000. Mr. McTighe wants to argue it's $185,000. I agree with him. That's a distinction without a difference. But in that 15 days, spending that much money on a focused campaign in Hamilton County to influence the judicial races there, as well as to engage in express advocacy, because we've got the advertisements in the American Israelite, it falls under that definition. Or at this stage, in terms of the procedure, there's probable cause that the Blake Mason Law Firm does satisfy that definition, and probable cause should be found. The matter should be set for full evidentiary hearing at some future date. Thank you, Mr. Chairman.
Go ahead.
Okay, at this time, I'd like to hear from the executive.
Actually, I'm going to say, are there any commission members that have questions?
Well, hold on.
Only because I have one, but I want to see if there's questions. Sorry.
Okay, we'll proceed that way then. Are there any commission members that have questions of the litigants right now?
I have none.
Before the executive director speaks.
Mr. Kreitz appears to.
No, I have no questions at this time.
Nor do I.
Okay, I have one question, I guess, as it relates to Mr. McTighe. 2 weeks ago, when the commission met on the One Worthington case, where there were arguments there related to whether and how someone may be a political action committee. How is this case different from that case? And so, Mr. McTighe, I would ask you to help me understand what the difference is.
Mr. Richter, certainly. In this instance, we have a political action committee, which, registered and which reported contributions that it received. So there was full disclosure. In One Worthington, there was no registration of a PAC, no reporting of in-kind contributions or monetary contributions. And the difference here, what we have here is a business entity, a law firm, has made in-kind contributions to a PAC. That was registered. That's the prime. I'm sorry, the prime.
You're gonna have to
There is a
repeat
PAC
yourself,
as
please.
With
You're muted, Don.
I'm sorry. Sorry about that. But as I was saying, there was a PAC registered in this current case. There was full disclosure by the PAC of all the contributions. And that is the primary difference. A second difference between this is that One Worthington is a so-called social welfare with multiple purposes. And there was no registration. So again, that is the primary difference here. We do have full disclosure. Thank you.
I have a comment or a question in regards to your question, Mr. Richter. I guess I feel, my takeaway is that this can't be a PAC because they're donating in kind to a PAC. So it seems to me the main defense of why it can't be a PAC is because it was in kind and contributing to a PAC, but I don't know that those two things are mutually exclusive. Am I misunderstanding?
I would certainly argue that they're not necessarily mutually exclusive, no. Whether you have a corporation acting or whether you are having, contributions made by that corporation, I don't see that as being mutually exclusive. I'm not trying to, I guess I am trying to make Mr. Hartman's argument here to a certain extent, but his argument is still that you have a corporation that is acting as a political action committee. I heard some of the same arguments there that I heard when you were making them against One Worthington in terms of corporation, more than one person, because otherwise I tend to view this as a Citizens United circumstance like I did on the other one. And my recommendation is to find no violation, but I'm still hung up on the fact that we set the other matter for hearing.
Yeah, Mr. Richter, this is Commissioner Kreitz. I would agree with what you just said there at the end. I think that Mr. Hartman has raised a number of legitimate factual and legal issues with respect to this law firm, not the least of which is whether or not it falls within the statutory definition of a political action committee. And while I understand that your recommendation is to find no violation, or at least that was before we heard the arguments, I have to confess to you, with all due respect to your position, that I find myself coming down on the side of the necessity for a full evidentiary hearing in this matter to kind of sort out all the factual and legal issues that have been raised. And I think this potentially is a very important decision. So that's kind of where I am at this point in time, sir.
I'm not saying you're wrong.
That is my position as well. More evidentiary, that Mr. Hartman should have an opportunity for this to go to a full hearing, conduct some more discovery, and find the facts to be able to make his case that this is a political action committee.
Mr. Chairman, I would move that we go ahead and set this matter down for a full evidentiary hearing, sir.
Second.
Was that Mr. Lyle?
That was Mr. Knight.
Mr. Knight? Okay, thank you.
We've had a motion that has been seconded that the matter be moved to a full hearing Is there any further discussion on the motion?
Mr.
Would any other
Chairman,
commissioners like to weigh in as to their thoughts before we vote?
Yeah, I think I was going to say, I'll interject for you, Ms. Tavares. Go ahead.
thank you. Thank you. I was just going to interject because I did not hear the arguments on both sides. I wish to abstain, Mr. Chair.
Okay.
Okay,
It's appropriate.
all right. All in favor of the motion, please signify by saying aye and raising your hand.
Aye.
Aye.
It's unanimous.
All opposed? Any abstentions?
I abstain.
Okay, Commissioner Tavares has abstained. The motion passes
Thank you very much.
6-0.
6-0.
Any final instructions to the parties?
Nope. I'll be in touch about trying to set this matter for hearing.
I do have an instruction. Mr. Hartman,
Yes, sir.
Mr. Hartman,
Yes, Mr. Chairman.
please wear a collared shirt or
I
tie,
po-
necktie.
I apologize. You did
Thank you
catch
very
me
much,
on
sir.
vacation. You did catch me on vacation here today, and I did not.
Maybe,
pack.
maybe I'm
My-
jealous,
My apologies.
but remember, there's a Walmart within 100 miles
No, there-
of wherever
thank
you
you,
are in
Mr.
the United
Chairman.
States.
Okay. Mr. Chair, members of the commission, the next case I would bring to the commission's attention is case number 2022G004, Hicks versus Stewart. The complainant has filed a complaint asserting that the respondent did not provide complete information in certain campaign finance reports. A response was submitted to the commission by the respondent. Mr. Hicks is here remotely. Mr. Stewart is present in the commission meeting room. Mr. Stewart would ask you to come over to Mr. Hughes' computer. And so.
Excuse me, Mr. Richter, this is Commissioner Price.
Oh,
Commissioner,
yeah, sorry. Go ahead, Mike.
I have a conflict in this case, number 2022G-004, and will be recusing myself. I would ask that the record respectfully reflect that. Thank you.
Okay, just a point of order here. Were we still considering having the parties argue all these cases at once?
No, this is separate
separate.
this is separate and distinct from the next three
Okay,
that Mr. Hicks is the complainant on, and counsel is present here for the Ohio Republican Party. And so, let me see, I'm going to do that. So, anyway, if the commission would like to hear further from the parties, you can certainly do so. We could have Mr. Hicks sworn. Mr. Stewart, even though your counsel, we have to have you sworn since you're here acting, since you were included as a respondent in the case. Mr. Hicks, you're currently muted. I presume you would like to make an additional statement. So if you would be sworn, if you would raise your right hand. Do you swear or affirm that what you're about to tell the commission is the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
I provided a complaint relating to Brian Stewart that ties back to an invoice that was part of case 2020G18.
Hold on, Mr. Hicks. I know I couldn't hear you. I'm not sure about anybody else.
I can hear him fine.
Yeah, I heard mine as well.
I'm just saying something to see if Mr. Richter, if you can hear me. Testing 1, 2, 3, 4. Do other people still hear me?
now we just heard him.
Well, you're intermittent, like I'm sure you were listening to the last case. It's kind of intermittent there as well, based on what I'm hearing here, and I think what the commission members are hearing.
No, I'm actually hearing them perfectly.
I'm not sure.
I am as well.
I'm hearing
not
him as
sure
well.
otherwise. I mean, generally speaking, it kind of comes back to internet connections, I believe.
At least we're improving. Some people can hear me perfectly and some people can't hear at all. But I don't think there's any issue with my internet connection.
No, it wouldn't be his, or we wouldn't be able to hear him. If it's, you know, it might be on your end, actually, Mr. Richter.
Ooh, I am?
Are you muted?
No, I'm not muted. Can you hear me?
Phil, can you hear us?
Well, no, I mean, we can hear you, Phil, but I mean, if you're not hearing and everybody else is.
I can see me move.
I've got the speaker on.
I'm
this
wondering
one,
if he
so,
can't even hear us.
When I'm talking and it's.
I don't think he can hear us.
I don't either.
Ah,
The university.
Is there a way that Mr. Hicks can call in using the telephone?
We can hear him.
Yeah, I don't think the issue is me, so I don't know that.
yeah.
Or
Yeah,
at
we
least
hear him
whatever's
fine.
happening
It's
in that
Mr.
room.
Richter that can't hear him.
Chair Beatty, can you hear us?
Maybe I'll email the.
Yes.
Oh, there we go.
Can you? Yeah, I mean, can you hear us?
We can.
But now I can know it's coming.
Yes.
We can hear everybody.
All right, go ahead, Mr. Hicks.
Fixed.
I just want to say, make sure, Mr. Richter, that you can hear me now. Is that a yes or?
Oh, I'm sorry. I apologize. I was nodding yes. I'm doing the court reporter worst thing, nodding my head.
Okay.
Yeah, go ahead. We're kind of hearing you through Mr. Hughes's computer here. It's, you know, it's a real interesting connection system, but
Okay.
right at the moment, yes, I can, you know, you're coming through. Before you weren't for whatever reason. Go ahead.
Okay, so my complaint related ultimately started with an invoice that was an invoice in matter 2020G018, the Alan Freeman case that involved 5 candidates that were part of that invoice. So I'm going to kind of, you've got the complaint. I'm just going to kind of address the response and the complaint all in one time. So again, and Mr. Hartman made reference to the purpose of a preliminary review of to determine whether probable cause exists for a commission to determine whether there is a violation of Ohio law has occurred. So I think that this is a matter that I see the director's recommendation to have no violation, but I think this is a matter that should absolutely be held over for a full hearing. So I've provided as part of the complaint an invoice that was testified to under oath in another election commission hearing as having been for 5 candidates and having been paid for by Constant Content. Mr. Stewart was one of those candidates. 2 of the candidates actually showed the expense on their financial reports. One of them, Alan Freeman, was already found to have a violation, and the other one, Gene Schmidt, is a candidate who there's a case already that's been
Hold on,
held
Mr.
over.
Hicks. Again, for some reason, we're getting various times where I apologize, but it's the joy of these remote meetings.
Are other people hearing me, or because it seems, I just want to make sure.
I'm hearing him perfectly.
I'm hearing perfectly as well.
Mr. Richter, I'm wondering if there are multiple computers or devices opened at your location. Only one of them can be unmuted at the same time, or else you're going to get interference. That might be helpful. I'm not a tech person, but I've seen that here in my work experience.
I think you're right on. Like the other one can be noise canceling and I think that's why in some of the other ones we're probably hearing some echoing because of 2 computers in the same room.
Is that better? Can you hear him?
I'm not sure how I'm to proceed. I'm sort of in the middle of something and have stopped and seems the technology is in the way of efficiency
Mr.
in the
Richter,
review.
you're on mute.
I'm trying to limit the amount of resources here, and so that's why I was muted. I'll apologize. I'm not sure what I'm really apologizing for because we want to hear what Mr. Hicks has to say. But anyway, I'm going to mute myself again. And Mr. Hicks, go try again.
Well, just to do all the commissioners, if I just clarify, obviously the commissioners are the most important people to be able to hear me. Obviously, Mr. Richter is important, and so I don't want to be redundant with saying things again if everybody else is hearing me clearly. Are all the commissioners able, are there any commissioners that are hearing me breaking up, or?
What I'm either hearing or not hearing is also coming through from Mr. Stewart and Mr. Beatty. You're right. I'm relatively irrelevant here, and I don't necessarily refute that. But that's the concern: is that there's other parties here.
Okay. Well, so I should start over basically, or pick up from where I was.
I think it'd be best to start over so everyone can hear,
All right.
from the get-go. If I'm
This
being
will be
honest.
one of those things where I'll do it like 7 times and eventually we'll get all the way through. So anyway,
You
I'm gonna
have to
start
hope.
over. Can you hear me? I'm going to start over until somebody interrupts.
Yes, we're good to go now.
Okay, so this complaint again relates to an invoice that was testified to under oath in matter 2020 G18 last year involving Alan Freeman, and that invoice was for 5 candidates for work that was done by Strategic Media Placement and was then billed and paid by Constant Content per under oath testimony in that other matter. Of those 5 candidates, 2 of them showed the expense on their finance reports. One of them, Alan Freeman, has already been found responsible for a violation by you. Another one, Gene Schmidt, has already been held over for a full hearing. And the last of those 5 is Mr. Stewart here, that has his portion of that particular invoice was $10,786. So I've provided that invoice, and I did research thoroughly which candidates had showed the expense on their reports and which had not, either as a expense, a debt, or an in-kind. And so I think that alone, just the facts that I've given you of 2 other candidates involved with that same invoice, one of them being found guilty of responsible for a violation, and one of them for a pending full hearing, means that this one, to me, it would be kind of absurd to me that this was not also held over for a full hearing. So I want to quickly hit on what Mr. Stewart provided in his response. So he did provide a lengthy affidavit response, but in that response, he actually confirms that he had a relationship with Jeff Longstreth, the Larry Householder people, and all of the principals that were involved in the same case that involved Alan Freeman. He also has in his own affidavit that he was repeatedly seeking bills from them, and eventually he was told, quote, "If you have not received anything by now, you're not going to." And in an admission that he received a demand letter specifically around this specific expense and invoice. It's interesting that he did not provide that demand letter, the actual demand letter, with his affidavit, but he did provide his response, which I think is disingenuous to this commission. So to me, when it comes to the probable cause for more evidence to figure out what happened here, this is I think that more than established probable cause. I don't know what else could establish probable cause. And Mr. Stewart's own affidavit indicates that he had a relationship, that he was trying to seek bills, and he actually received a demand letter relating to this money. Also, part of his response is very similar to the Alan Freeman response. I didn't know anything. I didn't know what was going on. I didn't know Constant Content. I just happened to know all the principles involved in Constant Content. So again, for all those reasons I've stated, I think that this is, to me, it would be bizarre that this was not over to a full hearing when the other matters involved with the same invoice for candidates who had not reported it have been either a violation or held over for a full hearing at this point. I know that Executive Director Richter's recommendation to you is to find no violation, but I want to point out that both in the Alan Freeman and Gene Schmidt matters, that was his recommendation as well, to find no violation. Again, I'm not asking you to find a violation here. I'm just asking that this be held over for a full hearing. So at a minimum, we can have some evidence, for example, the demand letter that Mr. Stewart's own affidavit states at one point they received related to this matter. This should have either been, the last point I want to make is in his affidavit, he talks a lot about expense and debt, but this either should have been expense, debt, or an in-kind. And the in-kind word is sometimes missing within his responses. And that's the gist of it. And so I appreciate the time to respond. And hopefully everybody heard all of that or heard enough percentage of it to have sufficient information to make a reasonably informed decision. I can't hear Mr. Richter.
I think you're on mute, Phil.
I'm sorry about that. I was merely swearing in Mr. Stewart, who did indicate, I thought that was going through the other microphone. I apologize. But Mr. Stewart has been sworn, so he can go ahead and make a comment as it relates to his response.
Can everyone hear me?
I can.
Seeing mostly nodding heads.
Yeah, I thought you were going to say, I see mostly nodding heads as well, so please proceed.
Commissioner Hagan, can you hear?
Well, first of all, appreciate the commission's time today and to the staff as well. I know long distance meetings can be difficult and appreciate your patience. I trust that everyone has read our very thorough affidavit, and so I'm not going to belabor those points again. I want to jump in on just a few things. Overall, every report that was filed in 2020 was true and accurate based on the information that the committee and all the respondents had at the time. It is uncontradicted in the record that no invoice, alleged invoice for alleged services was sent until more than a year after those reports were filed. And so even if there was some idea that something may have been discovered later, the reports were certainly accurate and not false statements at the time they were made. This is a disputed debt. This was sent a year after the folks in charge pled guilty to bribery, racketeering, and money laundering. Our committee and all the respondents have very good grounds to believe that this is simply nonsense, not a valid debt. And the argument that Mr. Hicks is essentially making to you is that he could leave this hearing today, go back and put on his letterhead radio ads performed by Hicks Co., send it to my committee, and that if I don't report it on a finance report, that we're guilty of an election violation. The veracity and the truthfulness and the accuracy of the alleged claim
Now I'm not hearing.
Number one, our understanding of that case is Mr. Freeman acknowledged that he had received an invoice during the time period in which he was obligated to make campaign finance reports. That's not what occurred here. We didn't receive any claim that services had been provided until more than a year after all of the campaign finance reports at issue. Another distinction is Mr. Freeman was not endorsed by the Ohio Republican Party. And so the mail that had been sent, and which everyone acknowledged had been sent, had to be reported from his own committee. In this case, I was an endorsed candidate from the Ohio Republican Party. The Ohio Republican Party sent mail on our committee's behalf, and every single one of those expenditures is listed on all of our campaign and finance reports as an in-kind contribution. And so everything has been accounted for. Number three, in the Freeman matter, there was pretty clear evidence that these mail pieces had gone out. This was not disputed. Mr. Freeman, I believe himself acknowledged he knew the mail was being sent. In this case, again, we've never approved a radio ad. We were never told a radio ad was being produced or run. We've never signed a contract asking for a radio ad to be run. And despite being a resident of the district, I have never encountered one human being who says, I heard your radio ad. So this, coupled with the fact that the folks involved are under federal indictment, gave us very strong grounds to believe that this was simply a fake claim for fake services that we obviously did not pay as a result. And so the campaigns records, there were no false statements included in the statements. That's why there's no 3517.13D violation, B violation, excuse me. All of the in-kind contributions that we received have been reported. Every expenditure has been reported. There's no 3517.10D2 violation. And Mr. Hicks's third claimed violation, this idea of receiving corporate expenditures or corporate spending. A, it didn't happen, and B, there's a knowingly requirement in that statute. And as the affidavit clearly lays out, we've had no knowledge that anything was done, run, performed in any way. And so again, no 3599.03 B1 violation. I think it is clear after the last 2 years that the way in which the former staff assisting Republican candidates for the House left an awful lot to be desired. Those of us who try to do the right thing and have been doing the right thing for our entire career have tried to address that in the best way we know how with the information that's been available to us at the time. I've tried to be very candid and open and honest about everything regarding this matter in my affidavit. Candidly, we looked for the original domain letter. I haven't been able to locate it. We're not disputing any amounts that Mr. Hicks says are on a separate invoice from Strategy Group. But again, an invoice from Strategy Group saying they build Constant Content has nothing to do with whether Constant Content billed us or whether that bill was valid. And so we're not trying to hide the ball here. It's uncontradicted that all the statements, all of the campaign finance reports were accurate at the time they were filed. This is a disputed debt. And that is the basis for why we would certainly concur with the executive director that this matter should be dismissed.
Go ahead, Mr. Chair.
Okay. Mr. Hicks, do you have a short response?
I have a very, very short response, is that this sounds a lot like the explanations that Alan Freeman gave at his original hearing. And the question here isn't, was there a violation? That I'm asking, the question here is there probable cause that there should be a full hearing so that we could, for example, go to the Goldstein law firm and get an original copy of the demand letter and better understand things that may come to light down the road. Like, there was never an invoice in the Alan Freeman thing until there was. So I think that the invoice that he's referring to was from, by the way, is from February 21st, 2020, which is more than 5 months before there were any indictments. And and it's already been testified to under oath by Scott Schweitzer as to a valid invoice and that these were the candidates it was for. All I'm asking is that this, like in the Alan Freeman case, like in Gene Schmidt that are tied into the same invoice, this should be a full hearing as well, because Mr. Stewart's made clear that this wasn't on one of his reports. Now, should it be? Shouldn't it be? I think that's something that I've blown away the point of, is there probable cause enough here that there should be a full hearing so that there could be a little more discovery on this matter? And I hope everybody heard me.
have any questions for either of the litigants.
I have a question for Mr. Stewart. There's a letter dated from you on September 5th to Mr. Goldstein. Was there where you asked him, what is the purpose of sending this letter? Did you ever receive an answer back from Mr. Goldstein?
Sorry, I was letting the question answer on my side. Just to recap, the first time, I'm sorry, I can't hear over myself on there.
Go ahead.
Go ahead.
There's a tremendous echo, so if somebody has the two computers in one room.
First time respondents received any indication that anyone was claiming that there was an outstanding debt owed was in the summer of 2021, roundabouts August of 2021. When I received that letter, came to my home, I shared that with caucus staff, shared that with their legal counsel. I explained the entire situation as I've laid it out in my affidavit, and indicated that I had knowledge of any radio ads. I had never approved any radio ads, and that this was, frankly, in my view, garbage. The letter was prepared with legal counsel to make clear if the entity claiming that something was owed wanted to provide proof that there were contracts or even that the services had been, we were in them to do that. If they had provided something to change our mind, perhaps we would have, adjusted prior reports or done something differently, but they have not. It's now been roughly 9 months. They never provided a contract. They never provided even an invoice. They never provided any documentation whatsoever to indicate that they had actually performed the services that they claimed had been provided. And so the purpose of the letter was to, in a good faith effort, see if there was anything we missed, but they didn't provide anything. And then so again, as then we're trying to decide how best to address this, the fact that they have made no effort or provided any documentation to verify this debt, frankly, was all the more evidence to us that it was not valid and not something that, frankly, should be reported. And that reporting it, candidly, would itself be a false statement potentially. That was the purpose of our letter.
Thank you.
So, Mr. Chairman, I have a follow-up to Ms. Kaufman's question. So I guess bottom line, they didn't respond to your letter in September.
I can't hear the question.
Hold on 1 second, Ms. Hold on 1 second, Mr. Mars. Okay, go ahead.
Okay, so my question is a follow-up to Ms. Kaufman's question. So bottom line, after you sent that September letter, they didn't respond. Okay, now we can't hear you.
That is correct, Commissioner. They did not respond.
Are there any other questions from commission members? Hearing nothing, is there a motion?
Mr. Richter, would you please restate your recommendation?
Sure. I respect the arguments that Mr. Hicks has brought before the commission today. I understand that, but after hearing, or after reading the response, hearing Mr. Stewart's explanation, seeing Mr. Stewart's written explanation, hearing his response, my recommendation is still to find no violation.
Thank you.
Do any other commissioners have any questions or comments on these matters? Seeing none. Is there a motion?
Echo chamber.
Gentlemen, that echo may be happening if your computers are too close together. So the chairman and Mr. Richter, if you guys, your devices are a little further apart. Sorry, I know that's not a motion.
All right, this is
I
the only
move
one
we
that's
follow.
on.
I move we follow the executive director's recommendation to find no violation.
Is there a second? Is there a second?
Doesn't appear. There does not appear to be a second, Mr. Chair. Is there another motion to be made?
Mr. Chairman? Can you hear me? I would
Yes.
move that we refer this for a full evidentiary hearing.
I'll second that motion.
Signify by saying aye or raising your hand.
Aye.
I don't think we heard everything you said, though, or at least I didn't. I would assume you were moving that motion.
Yeah, it was just a matter of, requesting clarification. Did you? Okay, I think I saw 4 votes in favor. Are there like sign for no? Ms. Kaufman, Mr. Beatty?
No.
No.
Yeah.
With Ms. Kaufman and Mr. Beatty voting no. So the matter will be set for hearing. Thank you very much.
Something I can speak to.
Well, I've got.
Okay. Hello?
We
No,
can hear
I'm
you.
not muted.
We can hear you.
Okay, so they can.
Yeah.
All right, let's take a 5-minute break to allow the parties to get set up and computers and all of that. The time is 11:36. Let's make it 10 minutes. 11:36. Let's come back at 11:45.
So if all right, now we don't have any.
Unless you want me to put the audio so it's coming through when people are speaking to us, they're coming through my computer, it's far enough away, as opposed to sitting right next to your microphone.
Hopefully, I just want to make sure we're not getting a whole lot of feedback, when it comes right down to it. I mean, that's what because, when that thing was, that was the problem with that thing. Okay. Presumably all the commission members out there can hear okay, and everybody's back. Mr. Hicks, you're muted and your camera is off. There we go. Okay. Hopefully everybody is able to hear and see. Mr. Chair, members of the commission, I'm going to call the next three cases before the commission. Case numbers 2022 G005, 2022 G006, and 2022 G007. Call them all together for argument's sake, not necessarily for decision. We can decide them separately, but the essential arguments are the same. Mr. Hicks has brought a complaint against three respective funds controlled by the Ohio Republican Party that filed campaign finance reports late. And so that's an essential case before the commission. Responses have been submitted by all three of the different funds. And so the commission has those responses. Counsel for the parties is here present physically in the commission. They are identified in Mr. Hughes's computer. And so I'll just remind you, Mr. Hicks, that you've already been sworn. And so you can go ahead and make a statement because I believe the commission would like to hear from you further. Yeah, okay.
Okay, can you hear me now? Like I got muted somehow. And so in these three cases, I don't think there's any dispute that the reports were not filed on time. I think that my position is there should either be a significant or the full statutory fine for that, or there should be a full hearing to better understand the actual circumstances of why these reports were not filed on time. The affidavit in response was filed by Justin Biz, who's the executive director of the ORP. He's not a party to this, nor is he the firm that was hired to file the reports. So his affidavit is largely hearsay since he wasn't involved directly. Henry Allen was the firm that was actually hired to file these reports, who advertises itself, it's a Dublin firm, to quote, our political accounting and compliance is our singular focus. So these reports were due on, they were for 2021 full year. They were due on January 31. They weren't filed till February 18th. There were actually four funds that the ORP has. One of them actually filed on time. Three did not file on time. And those, the three that, the restricted fund, the state candidate fund, and the 11 funds were the ones that did not file on time. I don't know if the commissioners are aware of the backdrop in which this all happened, but there on January 31st, there was an expose that ran on all Sinclair stations in Ohio about financial and accounting irregularities in the Ohio Republican Party. There was an Ohio Republican Party State Central Committee meeting that took place on February 18th, which happens to be the day that, per Mr. Biz affidavit, they discovered that they had not filed these reports. I want to put forth that there was a motive behind not filing them to avoid inspection by the press and by people that were at that State Central Committee meeting. So that's the fundamental to me in all this is that we haven't heard anything from the actual firm involved, which was Henry Allen. In fact, it wasn't even disclosed within the affidavit of what the firm was that supposedly did not file the reports on time. The explanation is basically that we lost the password, which seems crazy to me that you hired a firm that's supposedly experts in campaign finance reporting, and they didn't file your reports because they lost the password. And so bottom line to this, to me, is that this kind of behavior and what appears to me as funds that routinely for decades, I go back as far as you can go on the Secretary of State site, always filed on time, suddenly don't file on time in this 1 year where there happens to be a TV expose on irregularities in the financial reporting of the Ohio Republican Party. And then they happen to claim in their affidavit on the day immediately after the State Central Committee meeting, they discovered they hadn't filed the reports. And now, it's like, well, we shouldn't get any fine. There shouldn't be any, the position in the affidavit and the lawyer response was that there shouldn't be any fine at all. I know the director has recommended to you that there be a $50 fine. I think that these things are important. And I think that, frankly, either there should be a full statutory fine, which for across all three of these would be $6,700. That would be the legal maximum fine that could be given for all the days late for all three funds together would be $6,700. $2,200 for the restricted fund, $2,400 for the state candidate fund, and $2,100 for the 11 funds, $6,700 total. To make clear that this kind of behavior on a political party, the largest political party in our state that routinely filed these reports correctly year after year, is not acceptable. And it's not an excuse that we lost the password to do that. And there's also a context of an expose on Sinclair TV stations across the state that took place at the same time in a meeting where there was a benefit to this financial information not being disclosed in a timely manner consistent with campaign finance laws. So that's my position, is either it should be a full statutory fine or there should be a hearing so we can better understand and get information from the firm, Henry Allen, that wasn't even disclosed by the ORP, that was actually the firm that was contracted specifically to get these reports filed. Thank you.
Okay, if there are no, well, we could wait for questions until later. Okay, let me see. I guess I can I unmute them?
You cannot.
I cannot. They need to, or, okay. Okay, all right. Council is here for the ORP. And so if you would introduce yourself and make whatever comments you wish to make as it relates to the respective cases.
Thank you. My name is Anne Marie Spare, and I'm here with Rachel Maines as well on behalf of the Ohio Republican Party and Dave Johnson.
I'm going to stop you there for, is everybody able to hear them okay? Okay, fine, proceed.
Certainly, as Mr. Hicks already indicated, there's no dispute here that these filings did not occur on time. We provided an affidavit to the commission to provide context as to what happened. We could have not said anything at all and just indicated that they were not timely filed. But we provided that information so that the commission would be aware of this mistake. And again, as Mr. Hicks has said, this is the first time that this has ever happened with the ORP that anybody here is aware of, including Mr. Richter, who has been here for quite some time. So this was an aberration, a mistake. It was rectified. And we understand that the commission is able to impose whatever penalty is allowable under the statute. But we provided the context in an effort to show that the full penalty might not be warranted under the circumstances because this was a first-time offense. With respect to the expose, I can say that that had absolutely nothing to do with this mistake that was made. As pointed out in the affidavit, there was transition that had occurred with the firm. And that is the explanation given by Mr. Biss, who is the boots on the ground at the Ohio Republican Party, who's in charge of these funds. And that's what happened, and that's why he provided the affidavit, because he has knowledge. I am happy to answer any other questions. But we don't, we're prepared here today for whatever the commission decides to do.
Mr. Hicks, any short response here?
No, I just, my just very short response, because I failed to mention it, but I appreciate she mentioned it, is Dave Johnson is actually the statutory treasurer for these funds. And so I questioned the response from Mr. Biz when both the statutory treasurer and the firm that did the work, neither of them responded. But again, I'll just come back to the, my position is that this should have been this should either be a full and meaningful statutory fine to make clear that this should never happen again, or there should be a full hearing so that we can hear from Henry Allen or from somebody that actually was involved with this process, of which Mr. Biz was not.
Okay, thank you. Do any commissioners have any questions for the litigants?
Mr. Chairman, I have a question, or perhaps two. So, to the respondents, in the affidavit, why weren't the, particularly the new firm and that new firm's level of expertise listed in the affidavit?
Your question is why was
Yeah,
the
why,
name
why, you mentioned that firms were changed, but you didn't provide why, why the reason for the change, who the firms were, who you were changing to, just that there was a change.
Quite frankly, we didn't feel that was relevant. That we admitted that there was a mistake that was made and was providing context as to what happened.
Gotcha. So, I mean, whether there's a decision for what level of fine, for a firm that does this for a living, it seems to me that not having the appropriate information to do the filing would have come to light earlier in, really prior to. I mean, this seems, if the reason it's relevant from my perspective is that this is a firm, as Mr. Hicks says, that specializes in this. I mean, this feels like a pretty obvious miss that should have been, brought to light earlier than after the reporting period.
Is that a question? I mean,
it is. I mean, I'd be interested in your response to that.
It wasn't brought to light sooner. That's all I can tell you.
Okay, fair enough. Thank you.
Any further questions?
Mr. Chair, Commissioner Kreitz, I have a question of Respondents' Counsel, please. It was raised by Mr. Hicks in his argument that there apparently are 4 funds that are involved. One of them was filed on time and these 3 were late. Is there some sort of explanation as to why the one was filed on time, but the other 3 were late?
Commissioner Kreitz, this is Rachel Maines. I will answer that question for you. So the state account was filed on time because the firm had the login information. As we described, there was a transition in the firms in July of 2021. And there was a former ORP employee, and I say former because at the time he was with ORP, but he has since transitioned to another position. He was in charge of transitioning the firms, and he only provided one login.
Am I permitted to make a comment?
That's up to the chair.
No. At this time, we are, the questions were directed at the Respondents' Counsel. Right now, we're at the point where commissioners are asking questions.
Hello?
Do the commissioners have any further questions?
I have a question of Mr. Richter, Mr. Chair.
Please proceed.
Mr. Richter, this is a first time violation. What has been the general policy of the Ohio Elections Commission with respect to first time violations that are paid within a fairly reasonable length of time? And secondly, what consideration, if any, is given to the fact that, as has been raised by Mr. Knight and also by Mr. Hicks, that this is an entity, the Ohio Republican Party, that does this for a living, so to speak? How does that factor into our decision, if at all?
Well, I guess I'll speak to the more or less the first time violation situation, which is the primary basis for the recommendation that I'm making. Each fund is treated separately because they each are responsible for filing their own reports. And so the recommendation that I'm making in terms of a violation and imposition of a $50 fine in each respective case is because each was a first time party before the commission. We've kind of addressed over the last few months the general change that in policy that the commission has made in terms of being I guess I'd say imposing more fines depending on the circumstances. And so whereas, 2, 3, 10, 20 years ago, this would have been a violation but good cause. Now, because the reports were filed, but they were filed beyond about a week or so from the due date, I'm recommending the imposition of a fine, and the $50 fine is consistent with other fines for first-time persons before the commission. As it relates to experience of persons, again, I would look to how many times have they been before the commission and look to be consistent in approach for the same reason. Even experienced firms have problems sometimes where reports are not timely filed. And so I look to each individual circumstance, I look to each individual case, and try and factor that into the decisions that I make in terms of my recommendations. And so certainly it's a factor, but even experienced firms have those times when reports are not timely filed. I've tried to factor that into my decision here and in my recommendations, but certainly whatever fine, I certainly believe a fine is appropriate based on how long it took to get these filings submitted. But the nature of the fine is my recommendation. The commission can do whatever it believes is appropriate based on what it has heard, what has been presented to it in terms of the complaint and the response. I'll be glad to answer any of the questions the commission may have.
Mr. Richter, this is Commissioner Kreitz again. I just want to follow back up on that. One of the issues raised by Mr. Hicks, well, not issues, recommendation is that the full statutory fine amount be imposed for each of the funds. In your 25, 30 years, however long you've been here with the commission, have we ever had situations where we've imposed a maximum? And if so, are the facts similar to the facts that we have here in this case?
We do impose maximum fines, but it is generally in circumstances where parties have been before the commission 4, 5, 6 different times, not for someone, some group, some candidate, in this case, the party that is before the commission ostensibly for the first time.
Thank you, sir.
Any other questions here? Any other comments?
I have a quick question for council. When was it discovered that you didn't have the logins for filing?
I believe that's in the affidavit.
Okay.
It was around February 18th.
I'm sorry?
Around February 18th.
That's when they said that they were filed, but when did you discover you didn't have the login? So did you not try to file them before February 18th?
So in Mr. Biss's affidavit, he states that they discovered they were not filed on February 18th. The reports were then filed afterwards. His affidavit discusses how each fund was then filed about 3 to 4 days afterwards. I believe the exact dates are February 21st, February 22nd, and February 24th.
But my question that I asked was, when did you realize you didn't have the logins? If they're due January 31st.
I cannot answer that question. I don't have knowledge of that.
Thank you.
Anne Marie, do you have anything to add?
No, I just know it's in the affidavit. They weren't aware that they had not been filed until February 18th, and I think that's when they found out why they weren't filed.
Thank you.
Any additional questions? Mr. Hicks, any final comments?
I appreciate that opportunity. The one thing I just want to point out is, again, along the way there, this firm, one of four of them, they had the password and they filed. 3 of 4, no password, no filing. It's completely implausible that they filed one and had the password and never bothered to alert anybody that they couldn't file the other ones because somebody lost the password. That makes no sense. And then I'll put it in the context of, there was, because of the stuff that was happening on TV relating to the party, I think there was an incentive to delay the filing of these, to put them after certain things appeared on TV and after an important meeting. But I'm going to go back to just the simple thing. By their own testimony, it just makes no sense that a professional firm to file reports would go ahead and file one, but not bother to alert anybody that they didn't have the login information for the 3 other of the 4. But thank you for giving me the chance to make a final comment.
All right. All right, is there, hearing no comments or additional questions, is there a motion? I'm sorry, we'll handle these one.
Please. Yep.
Yes.
So I was
sorry
going to
about
say, yeah, I guess what I would say to the commission members, is there a motion on case number 2022 G005?
I move that we follow the recommendation of the executive director.
Is there a second?
Second.
Okay, we have a motion that's been duly seconded. Is there any further discussion on this motion? If not, all in favor signify by saying aye.
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 Aye. Raise the.
Or raise your hand. Opposed, like sign?
Opposed.
Opposed.
Mr. Knight is opposed.
Okay.
006.
All right, the motion carries. All right.
006.
Let's call the next one. All right.
Is there a motion concerning case number 2022 G006?
I move that we follow the recommendation of the executive director.
I'll second the motion.
That was Mr. Lyle.
Okay, all in favor signify by saying aye.
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 Or raising your hand.
All opposed, same sign.
Opposed.
Thank you.
All right, motion passes by a vote of 6-1.
Correct.
All right. And the final matter is case number 2022 G007. Is there a motion on that?
I move that we follow the recommendation of the executive director.
Is there a second?
Second.
That was Ms. Kaufman.
Okay. There's been a motion that's been duly seconded. All in favor signify by saying aye and raising your hand, please.
Aye.
Aye.
All opposed, same sign.
Opposed.
6-1.
All right, motion
Mr. Knight.
motion passes 6-1. Respondents council, do you have any questions regarding?
No, thank you, Chairman.
Thank you.
That is all the
right,
business
that's-
on today's agenda, Mr. Chair.
Is there a motion to adjourn?
So moved.
Second.
Is there a second? All in
Second.
favor, signify by saying aye and raising your hand.
Aye.
Aye.
All right.
Thank you very much, everybody.
Thank you.
Thank you.